Todino versus the town of Wellfleet.
Mr. Mason?
May it please the Court, Your Honor, I represent the town of Wellfleet, and I guess in this particular case, other municipalities as well. The issue was the interest issue about a waiver of municipal or sovereign immunity. Basically, what happened is the lower court found that even though Chapter 41, 111F, and this was a Chapter 41, 111F compensation case for a police officer, they found that even though General Law, Chapter 41, Section 111F does not expressly address the question of whether interest is recoverable from a government employer, they went on to find out that there was a waiver of sovereign immunity and that interest should be paid in this regard. I believe that they based it on cases by the Supreme Court, by this Court, addressing Chapter 151B, where this Court found that there was a waiver of sovereign immunity under 151B by the express terms of the Chapter 151B statute referencing employer and the fact that an employer included the Commonwealth of Massachusetts. In this particular case, what the Court of Appeals said is there's no express terms that address interest. There was no express terms that such as were found in the 151B cases that were addressed by this Court. And it's my assumption that this Court was addressing them under the provisions of Article 20 of our Constitution, which says that a waiver such as this should not be done other than by the legislature unless the legislature has expressly provided for.
What about by necessary implication?
Pardon?
By necessary implication.
I'm sorry?
Waiver by necessary implication.
Waiver by necessary implication.
Right, but without the express,
correct,
any express provisions in the statute, I don't understand that.
Well, there is an
I mean, I believe this Court had indicated that in the statutes that they did it in, there was an express provision in the statute involved that said, for example, employer. An employer is a person, and the Commonwealth is in that definition, so it is an express waiver. There was no such reference or no such implication.
There's no reference at all in this statute, is there, to interest?
Well, there is a reference to interest.
There is reference to interest, but it's third party.
It doesn't apply.
Pardon?
It doesn't apply, or does it?
Well, interest doesn't apply. It applies on the third-party liability in 41-111F. It was provided in there in that regards, but not for
a direct employer.
Not for the employer. And in fact, the Court of Appeals spelled that out.
Let me just stop you there, Mr. Mason, and I realize I'll ask Mr. Freeman the question because it really goes to him. If the legislature in drafting this very same provision explicitly provides for interest and I'm just trying to find the statute, for interest and inclusive of interest and costs for third parties, can't we, under the normal rules of construction, don't we say that if it doesn't provide that for somebody else,
well, under normal construction,
give it to somebody else?
Under normal implication, Your Honor, I would think that we'd be looking at it inclusio unus, exclusio alterius. If they knew that interest was an issue to be addressed in this statute, and they included interest for third-party liability, but not for the direct employer liability.
Is this really?
But as a matter of fact, they excluded it for the employer.
Isn't this really a claim that sounds more in contract than in tort?
Pardon?
Isn't this the nature of the claim under Chapter 41, Section 111F? It's essentially a contract claim, isn't it? It's not a tort claim.
Not to my knowledge, Your Honor. That was not a finding by the court.
It was brought as a declaratory judgment action, correct?
Right. The Declaratory Judgment Act.
Not as a suit on a contract.
I'm sorry? I have tinnitus. I don't hear too well.
yeah.
I'm sorry.
This case was brought as a declaratory judgment action seeking a declaration that the officer was wrongfully discharged and should have been paid their full salary for this period of time. And the court entered a declaratory judgment saying, yes, wrongfully discharged, should have been paid the salary. That was it.
Yes, Your Honor, tort.
No.
Well, in the nature of a
A
tort.
declaratory judgment under the statute. As to
Yes, a judgment under the statute.
Not in the nature tort, it's declaration of contractual rights.
Well,
Or
I
rights,
believe,
statutory rights.
I believe there's several cases that also point out that, that 111F benefit is not a contractual right. It's not a vested right. It's a right that's there by terms of continued progression of an inability to perform any one of the functions of a police officer or firefighter.
Yeah, but the wrongful termination that you're talking about, the award of damages here wasn't for emotional distress or the kinds of things that you might also get under the tort of wrongful termination. She was essentially saying that she was entitled to continue to be paid her salary as a police officer.
Yes, Your Honor.
She essentially recovered lost wages.
Yes, Your Honor.
Isn't that in the nature of a contract?
I can't answer that, Your Honor. I don't think so. I think it's in the nature of an appropriate remedy for, as opposed to the cases that this Court's decided, an intentional wrong under 151B. This was not an intentional wrong. This was a judgment by a community that an individual was insubordinate by not providing documentation to continue their compensation, to continue to stay out.
Did she get a W-2 form for the money under Chapter 111F, under Chapter 41, Section 111F?
A W-2 would be provided for
And that's for wages, isn't it, for salary? She pays a tax on it?
No tax.
There's no tax on that?
No tax, Your Honor.
It's a this is basically for police officers and firefighters, I take it.
Yes, Your Honor.
Is the disability statute that relates to them.
Right. That's why the Court of Appeals, how can I say it? They looked at 152 as well, and they said under 152, there's a provision that addresses it, but there isn't under 111F.
Well, for one reason, one possible explanation is that for people in other occupations, for disability, they get 80%.
60, I believe.
Or 60.
Yes, Your
Not
Honor.
100%. She was.
Well, the police officers get 100, and under 152, they get 60. Yes. Police and fire get 100% of their pay tax-free while they're out, and there are several cases that say, because of this, they have to continue to provide documentation as to their ability to not perform any of the functions of their job. If they can perform any of the functions of their job, then they're supposed to return and perform those functions as opposed to staying out collecting 111F. That was the issue involved here. The chief was trying to find out what the individual could do as opposed to couldn't do in order to provide work. The individual didn't provide the data. There was a hearing and a termination.
Let me put it this way. Let me suggest to you this. That's okay. The sound bounces.
It's me, not you.
No, Mr. Mason, it's fine. I take it that the chief of police was trying to make sure that if she was making legitimate claims, he had done everything that he could to make sure that she really was disabled and she wasn't giving him the documentation, correct?
That's exactly, well, more than that, he was trying to, there's, in the record it will show that he was trying to provide her with work in order to get her back gainfully occupied. She was going to law school at the time, and he needed a prosecutor. So, but the big thing, as I understand it, is that the premise was based on case authority from this court, and the case authority from this court, as I understand it, was done, and I am assuming, based on the constitutional provisions, Article 20, expressly finding a logical connection or nexus in the statute involved, 151B, while there is nothing in 41-111F. In fact, this court said that they were going to go outside the realm of the statute in order to find a logical connection. And they cited case law talking about going outside of the statute to find a logical connection. That's not what this court did, and I believe that they made their judgment on an incorrect situation. In other words, no express provision, then there shouldn't have been the assumption. Plus, in the cases that this court did it, there was a remedial administrative agency dealing with an intentional wrong, as opposed to a non-remedial, non-administrative agency that, as a matter of fact, was dealing with an equally reasonable judgment that was determined wrong, but not intentionally, willfully, maliciously wrong.
Thank you, Mr. Mason.
Thank you.
Mr. Freeman?
Thank you, Madam Chief Justice. If it pleases the Court, Peter Freeman, representing the injured police officer, Todino, from Barnstable, where I'm happy to say there are also still many boats in Barnstable, not just Florida.
Can we admit right off the start that there's nothing in this statute that awards interest to this woman?
It is correct that the words in the statute, in terms of interest, do not use the word interest or to pay interest.
Why shouldn't we leave this to the legislature to fix?
Because two things. There is the doctrine that this Court has recognized and repeated many times, that notwithstanding the sovereign immunity doctrine and that it should be only very sparingly broadened, that there is the need to sometimes look at the necessary implication of the statute.
I recognize the doctrine, and there are many cases where we've done that, but it seems to me quite peculiar to do it when the very same statute does provide interest and costs, as I recall, to third parties. In other words, if she had sued a third party, not the Commonwealth, she gets interest and costs.
The distinction is this. It is true that it's there in the second part or third paragraph, which is a separate part of the statute. The difference is, I submit respectfully, it's apples and oranges. That part that talks about interest doesn't create any right. The dispositive part of the statute, which has words that I'll get to that by necessary implication would logically require interest. The part that does talk about interest simply allocates if there happens to be a third-party tortfeasor and if there's a recovery by the injured officer or firefighter. The statute, the legislature did say, yes, the allocation will include both the basic damages that are...
What part of the statute do you say necessarily requires the payment of interest?
As the appeals court states, there are several very key words. First, when it talks about how the pay is to be made, and it does sound much more in contract than tort. There are cases that clearly say it's not a wrongful tort recovery. But the words are that the compensation shall be, I'll get it exactly.
Paid at the same time and
At
in
the
the
same time and in the same manner as the regular compensation as the police officer. And unless you want to say that the legislature has no knowledge of the time value of money, it is inconsistent with the purpose of the statute, which is to make the injured police officer whole.
But how is that different, I must say, from any statute that requires the Commonwealth or municipalities, obligates them to pay money to certain people? Nobody sues somebody, at least not normally, until the money is overdue, or at least the litigation takes some time, and the payment on the judgment isn't going to happen till sometime after the money was originally due. It seems to me if we accept that there's a waiver of sovereign immunity by necessary implication here, it's an exception that would swallow the rule. You could make the same argument anytime. There's that to pay someone the equivalent of this money when there has been a delay, it isn't really the equivalent unless you add interest, and therefore by necessary implication, the legislature must have intended interest. I don't see how we could, in other words, cabin this case in a way that wouldn't just award interest in every case.
Excuse me, I think that you can, Your Honor. The distinction would be the very words that we're referring to, and more that I'll mention in a minute, that are in the statute and are not in other general statutes talking about an unpaid debt or a contractual breach. Certainly, it's true that there is a general application statute about awarding interest, but it doesn't. It's just general. In terms of the substantive right, this statute gives to police officers and firefighters, if they're injured on duty, it gives them the right, not the right, it's an entitlement, and the towns are obligated to make the payment timely and as regular compensation, which does sound in contract. In the Thibodeau case, which was a case where there was an award under the retirement system, where there was a wrongful demotion of a firefighter, I believe it was, in Seekonk, and the court made the distinction that that payment is really a contractual payment, and without any mention at all of interest in the statute, it said that interest is applicable, both pre-judgment and post-judgment interest.
Mr. Freeman, may I ask you this question? We're talking here about a disability, correct? So we're talking about police officers and firefighters with a disability. One way to read the same times and in same manner is when somebody is out on disability, you have to keep, it both protects the injured worker and protects the employer. The injured worker can't ask for a lump sum payment. I'm going to be out, my doctor says I'm going to be out for 6 months, and therefore I want the full payment now. And it also protects the injured worker, so the employer, while the worker is out, everybody understands that the payments are due to the worker, they shall just keep paying them in the regular way. It doesn't seem to me to address this case where there's a dispute, where the employer said, we can't continue to keep you as an employee unless you give us evidence that you are disabled. Otherwise, we end up on the front pages of the newspaper. We can't have pictures of you going over to law school doing what you're doing. I'm not suggesting she was. I want to know how disabled you are. If you don't tell me, I am no longer going to treat you as disabled. There isn't an agreement that she's disabled and the town has to continue to pay her.
I can answer both parts. You're really asking two things in terms of the interest assessment and the substantive right. It is true that the town has the right to make sure that there's an ongoing disability. What happened here, and this gets into the public policy aspect, and not as the Attorney General says that you should substitute your determination of public policy. Yes, that's for the legislature, but I respectfully say that you can infer that the legislature has good public policy in mind. And in this case, all that happened was a doctor was slow in getting a medical questionnaire.
But it's a condition precedent to her right to receive the money, isn't it? Even if it is a contract claim. She doesn't have the right under the contract to get the money until she complies with the terms of the contract, which is to provide a timely certification of continuing eligibility.
That's essentially correct. The way it works is that the burden's on the town to have an examination and to basically show evidence that there's an ability to go back to work. But yes, in that sense, it's a disability. It's a bit of a hybrid. It's a disability. It clearly is compensation, which is more like wages because of the words in the statute, the regular compensation, timely paid. The other interesting words in the statute that I think by necessary implication give the reading and the interpretation that the appeals court did is it is referred to in one of the paragraphs as leave without loss of pay. So we can really parse words as to whether it's a disability or a contract, but it's clearly leave without loss of pay. The legislature intended that they're to receive their pay. And in terms of the public policy, sovereign immunity, which we understand, and that's what we have to deal with, the public employees, but the whole point of the sovereign immunity in this instance is to protect the purse, the treasury of a public entity, the municipalities. In reality, and the legislature recognized it by mentioning timely payments.
But again, you haven't implicit in that is that everybody agrees that the worker is disabled and the worker is not showing up for work. And the legislature might well have wanted to make sure that where everybody agrees that it's a disabled worker and the disabled worker is still on the payroll, that disabled worker continue to receive timely payments.
Correct. But what you have to ask yourselves, could the legislature have expected and intended that it would take 6 years, that there could be 6 years when there's no payment, and is the meaning and purpose of the statute to protect the income of the injured police officer truly being carried out when they can be not paid all that time and not receive interest, and there's no harm. I know we have the doctrine of sovereign immunity, but there isn't the harm. In fact, it was more like a windfall to the municipality. They didn't have to make the payments.
As I understand it, it's maybe from the amicus brief of the Attorney General, but the Commonwealth has waived sovereign immunity to contempt, has waived sovereign immunity to Chapter 231, 6F. So it's not a situation where a town can act with impunity. Your client went in, she got a declaratory judgment that led to an order. The order is not being obeyed. She can go in on contempt. I gather a contempt motion was in fact filed. If there's a claim that the town has been litigating this in bad faith, you can seek things under attorney's fees and whatnot under 6F. It's not that the town can just completely ignore this and that interest is the only way that we could excuse me, enforce it.
There are, in theory, alternative ways to try to get some type of either punitive damages or interest fees and interest and attorney's fees, such as the 231 Section 6F, but I respectfully submit that, again, those are apples and oranges. It doesn't obviate the need to determine what the legislature intended, and those remedies, by the way, are also very problematic. I don't want to use the word subjective, but there's a high threshold standard to show that the town was willfully making a frivolous claim, so you can't depend on those types of things to make the officer whole. And I also would argue that the Attorney General and Brother Counsel makes the point that in the other statutory schemes, because don't forget, interest is allowed, even though they're sovereigns, against the municipalities and the Commonwealth. It is allowed in decisions of the Labor Relations Board, and interest is allowed in awards by the MCAD.
And is that because, as I recall those cases, because the legislature delegated to those agencies broad authority in designing remedies? And by necessary implication, we said those remedies could include a whole variety of things. But we don't have that kind of delegation here.
You do recall the cases correctly. That is what your holdings and the appeals court holdings state. I agree. I would submit that in this case, where in fact it's an entitlement, yes, you do have to be disabled. There's no getting away from that. But essentially, your regular pay at the proper time as regular compensation so that your pay is protected. That's an entitlement. Does it really make sense the legislature, in delegating to a board like the Labor Relations Board or MCAD, says you have the discretion, but you don't have to, depending on the determination that you make on the facts, et cetera. You don't have to award interest. You have the power to interest, and the purpose is to make the injured employee or wrongfully.
And if the legislature had intended that, they clearly could have provided it, as they provided that interest could be collected from third parties in the same statute. So yes, you're right, and they could well have provided it. They chose not to. Now, you're saying by necessary implication, but it seems to me what you're saying is by possible implication, probable implication, necessary implication. That is a very tight window. The statute can't work without it, in other words.
I
don't think that can be.
I understand it's a tight window, but don't forget that when the so-called delegation takes place, the fact-finding and award-finding authority of the Labor Relations Board or MCAD or the Retirement Board, in that other case, Thibodeau, again, there is absolutely no mention of interest. There are many circumstances where damages don't have to include interest. So the legislature
Right, but those statutes delegated to an agency the authority to basically design remedies that it deemed appropriate. Now, that was the basis of our holding in both of those cases, that in such circumstances, in essence, sovereign immunity was waived with respect to the types of remedies that those agencies might thereafter devise.
I agree that that is the correct summary of those cases. Again, I would submit that when the legislature clearly intended that there's a time value of money, and it was an entitlement, no discretionary board to make a discretionary determination as to whether the payment gets made, that it is even stronger that interest is needed to make the injured employee.
The Attorney General makes an interesting point here along these lines, and that is that actually in Chapter 41, 111F, there really isn't even an enforcement mechanism.
Well, I noted that too, and I don't know what to make of it, because to me, talking about swallowing the rule, I can only respond respectfully to the Attorney General. That almost makes it sound like the Attorney General is arguing that there's really not even a remedy, and the legislature intended that police officers who were injured and firefighters receive their regular compensation timely if they're injured, but gee, if the city doesn't pay, well, you don't have any remedy. Now,
Seems odd.
it seems odd, and I think that,
Is
you know,
it-
But there are often rights without remedies. We
there
know
are
that.
sometimes rights without remedies.
Sometimes.
Quibble on the often versus sometimes.
Is
But
it grievable?
well, it's not grievable for this officer for sure, because she was a special police officer, so she wasn't under any of civil service or collective bargaining agreements. And that is important to keep in mind here. This was, you know, through 231A, was
Mr.
essentially the
Freeman,
correct remedy.
If I could just ask in closing for you, the cases that you relied on and on which the appeals court relied, I haven't had a chance to read. I know you said in your brief that Politano, the award of interest, was not at issue. Was it at issue in Thibault or Blair?
When you say it wasn't, interest was at issue in both of those cases.
No, I know there was an award of interest, but was it contested?
Authority.
In Thibodeau, definitely. In Politano,
Okay.
not directly. It was the distinction between the Tort Claims Act, where the court said it's not a tort, it's a statutory right, more akin to the contract. The only other case, I know my time is up, but just Berube, because for a long time this court has recognized, really back to 58, Berube, the citation is 336 Mass 634, and although it didn't use the word sovereign immunity, Edgartown, it was Berube versus Edgartown, Edgartown challenged the legislature's imposing this obligation through the prior statute, Section 100. They said, you can't even make us make this payment because it hurts our treasury, same types of arguments. The court back then clearly said, no, the legislature has the right to make you compensate injured police officers, and they went on to clearly assess the interest. So it's been part of our case law for a long time that interest goes parcel and parcel with making the injured police officer whole. Thank you very much.
Thank you, Mr. Freeman.